Welcome everyone to the second hour of the Employer Handbook Office Hours. Appreciate you all for coming out. Hope you enjoyed the first hour. If you missed it, we talked data privacy, we talked vaccinations with Simone McCormick and Amy Epstein-Gluck, my partners. I'll drop a link to that video down below if you're watching this on YouTube. And if you're watching this on YouTube, hey, give us a like. Subscribe to the channel. We'd love to see you around more than once, all right? But for the rest of you who are doing this live, welcome. We have almost 200 people here with us. Great. And among those 200 people are my special guests, Mark Mathis and Bob Ellerbrock, who I will officially introduce or allow them to introduce themselves in a bit. My name is Eric Meyer. I am an employment lawyer at FisherBroyles. And I am also the publisher of a blog called The Employer Handbook. Thank you all for being here today. Bob, thank you for being here today. How you doing?
Well, thanks for having me.
Want to tell everyone a little bit about yourself?
Sure. I'm Bob Ellerbrock. I practice in employee benefits and executive compensation. I've been doing this as if you heard earlier, Mark talking about the senior attorneys or the older attorneys back in the day. I've gone from being the younger one to now being the older one. I practice a little bit in everything employee benefits, as Mark was discussing earlier. It's become a little more specialized. The young attorneys coming up kind of deal with, maybe retirement plans, and they have another that will deal with welfare, one that deals with COBRA. I grew up in the generation that kind of the practice size. So we'd like to say that we were old and kind of still think that we can do everything and never gotten that specialized part. But, I appreciate Eric having us today to talk about this COBRA issue. And, COBRA is always fun to talk about.
Suit yourself. But we'll make it fun for the next hour. Mark Mathis, how you doing?
I'm doing good. How are you doing today?
I'm doing real well. Why don't you tell everyone a little bit about yourself and what you got going on?
Yeah, my name is Mark Mathis. I started practicing in employee benefits law in 2001, just after I graduated from Georgetown Law with a master's in taxation, and I also earned my certificate in employee benefits law. So I've been practicing a little over 20 years exclusively in this area. I have been trained as a utility infielder in my practice, so I will deal with everything from qualified plans to welfare plans. By that I mean medical, dental, disability, AD&D, death benefits, everything else, and then into executive compensation. And so it's a pretty broad waterfront. Bob is absolutely correct. It's become much more arcane and riddled with nuances in the past 10 years, 12 years. And so what we do see is people specializing, but with the cumulative knowledge, it really makes it a lot easier to switch from the different areas. And COBRA is one of the more complicated areas. And as I was talking during the break, COBRA is just a really totally artificial construct. And so the ARPA made some changes to this for us. But keep in mind too, that not only did ARPA change things with respect to COBRA, but it also changed some 162M issues with respect to the annual $1 million deduction, and certain executive compensation restrictions were placed on air carriers and related contractors. And so there are other pieces of benefits in ARPA, but today we're just going to focus on the really fun one, which is COBRA. And essentially what ARPA has done is provided a subsidy. It's a 100% subsidy for COBRA coverage that begins on the date it was enacted, which is April 1st of 2021, and it ends on September 30th. And so anyone who is an assistant eligible individual is entitled to receive the subsidized coverage.
Can I ask you a question about that?
Yes,
Well,
sir.
actually, I want to do one thing before we go any further, Mark. I didn't mean to cut you off there. Folks, just a brief disclaimer. Mark's a lawyer. Bob's a lawyer. I hope I'm pointing in the right direction when this shows up on YouTube. I'm a lawyer, but we're not your lawyers. Although I do see some clients in here for the next hour, we're not your lawyers. We assume that every question you ask in the chat window is hypothetical and you're asking it for a friend, okay? We're not giving any legal advice. We're not creating any attorney-client privilege. This is a free Zoom. Treat it as such. If you need legal advice, pay for it. Go contact your lawyer after this is over and get some legal advice. But I'm sorry about that, Mark. I just wanted to make sure people know that even though you're giving an excellent recitation, that no one should rely upon this as the gospel without consulting outside counsel. You were talking, I'm sorry, Mark, I interrupted you. You were talking about eligibility for the COBRA benefit.
No, and I'm glad you did interrupt me, actually, because I missed out on something that Bob and I talked about earlier today. Back in 2009, we had the American Recovery and Reinvestment Act, and it had a COBRA subsidy provision in it as well. The COBRA subsidy provision in ARPA is similar, but there are a lot of differences between what was enacted back in 2009 and what just became law. And so some of this ground has already been tilled. I spent some time looking at old Notice 2009-27. I don't want to get into the weeds, but a lot of the themes that you may see coming out are going to be familiar to you from 2009 if you were involved in COBRA during that period. We have not gotten to date any guidance from either the Department of Labor through the Employee Benefits Security Administration or from the IRS through employee plans. I expect that we will be getting a notice here pretty soon from the IRS. It's going to probably run, anywhere from 15 to 20 pages, and it's going to have a lot of nuance in it about applying these rules because, we've got this subsidy overlayered onto COBRA's superstructure. And so there are going to be a lot of nuances that we're going to be dealing with. So we can't anticipate all of those right now, but we've got some ideas of what we think the service will probably be doing. And we'll get to that with you guys, and then we'll tell you things to be working on now. For example, go and talk to your third-party administrator. If you're self-insured, you've got United Healthcare as your TPA, and you're buying their network, or your insurance company if you have insured product. You're also going to need to go back and look at who the eligible assistance eligible individuals, the AEIs, are, and start looking at the population there. And then also you're going to have to coordinate with your payroll function, because the way the subsidy is captured is it's captured through offsetting employment taxes. And so, there's going to be some interaction on that. But with that out of the way, I'm going to let Bob jump in right now, and he's going to talk about a bit of a summary, and then we'll kind of switch off back and forth and hopefully cover this fairly quickly.
Okay.
Yeah, I was to follow up on what Mark was saying as far as talking to your COBRA administrator. And this is something we, not just now, but always with COBRA, always remember that you're ultimately responsible for COBRA. Even though you've outsourced it or delegated to someone else, you're responsible for them doing everything and making sure that things are operating correctly. In this case, it's a good time to go ahead and get on the phone with them or start some sort of correspondence to see what their plan is, if they're going to help identify the individuals that are going to be eligible. They're going to be eligible. It's going to go back and my math isn't great always, but I think sometime November of 2019. It's going to be 18 months back from April 1st. So you're actually going beyond the beginning of beyond the beginning of our recognizing the pandemic, I guess, in March of 2020, right? So it could actually dip into 2019 when we first really started hearing about the coronavirus, but it is 18 months back. So be aware of that. Go ahead and talk to your COBRA administrators to make sure that they have a plan in place, that if they're going to help you identify. Right now, we don't have a model notice. Should be coming out. Again, not great in math, but I'm guessing within 30 days is what they said is going to be out. We do have an idea of what we can add to those notices. So some of the providers may already be working on that. And I'll just turn it back over to Mark right now.
Okay.
But it is important to go ahead and get started on identifying the people that have to receive the second chance, or the second bite at the apple on COBRA, and go ahead and make sure that everything's in place with your provider.
Before you continue, I hope I'm not catching you guys flat-footed. There are a couple of questions about the timing going back to November.
Mm-hmm.
And there was a comment, one person wrote, Marta wrote, for us, it would be people termed in October of 2019, since their COBRA would begin November 1, 2019. Is that consistent with your understanding that it's when the COBRA would kick in? Or
that's how we're reading this right now. And of course, you know, who knows what the IRS is going to do. The statutory basis for the subsidy is different in ARPA than it was in the American Recovery and Reinvestment Act. And what we're thinking right now is that anyone that could still be on COBRA coverage because of a involuntary termination of employment, that's the 18-month period, if that stretches and is applicable beginning on April 1 and ending on September 30th of 2021, they do become eligible for the subsidy for that period of time. So you're going to have two buckets here. You're going to have people that are on COBRA that you know about because they're still on COBRA, they're paying their premiums and whatnot. But you've also got another bucket of two people, or two different groups of people. And in that second bucket, you have people who elected to take COBRA coverage because of an involuntary termination from employment, but they didn't pay their premiums and then went off of COBRA. Or they didn't elect COBRA at all. That's our second group under that second bucket.
Right.
You've got a special enrollment election that needs to be provided to those people, and that's the notice that's going to be the notice that the Department of Labor is going to owe to us within 30 days from April 1. And so they're going to, the COBRA administrator or the group medical plan, or maybe it's an internal function within your HR group, is going to need to be geared up to be prepared to send that notice out to those people. So you're going to need to go back into your systems and figure out kind of who those people are. Now, not to get too far into the weeds on that, but, an involuntary termination of employment, we could have a variety of different rules that are built around that. And so what we're going to need to do is, as soon as the IRS gives us what we expect to be a notice, they're going to tell us all these nuances. And so, for example, in the ARRA, or the 2009 law is what I'm going to call it for this purpose. If somebody had a good reason for terminating, we could have a voluntary quit. If they had a material reduction or material change in their employment situation, such as being demoted, a variety of different things, if there's a good reason for them to have terminated, that can count as an involuntary termination.
Got another job offer that happened to fall through, right? Something like that. Yeah.
And so, there are going to be a lot of nuances that are going to come out, but if we're correct, and we're going to have to go back and look at everybody who had an involuntary termination, and their 18-month period could be, at any point during April 1 through September 30th, then we're going to have to ping those people if they're not already on COBRA coverage. And so managing that is going to be a very difficult task. we need to start getting our arms around it.
What about quitting due to COVID? Someone just asked, what about quitting due to COVID concerns?
There wasn't, well, we had different facts back in 2009. We didn't have a pandemic. We found on Wall Street, and there may be a provision in there that allows for a voluntary quit to avoid to avoid being exposed to COVID if you're in a frontline position where you were going to be exposed. And so that's not in the legislation, but it would not be beyond the Internal Revenue Service to go in and take nuances like that into account. We just don't know at this point because it's,
I would say right now that's not in the statute at all.
Yeah.
So that's not to say it won't be there, that the guidance won't come out and expanded a little bit, but as of right now, the answer to that would be that would still be voluntary.
Yeah, it's the statute is remarkably broad, and so the Internal Revenue Service will come in and give us all types of scenarios where we're going to have an involuntary termination, and that was, the notice 2009-27. When I read it, 15 pages of it were Q&As about what is involuntary.
And it's similarly silent on going to the other end of the spectrum, what gross misconduct would be to disqualify someone from COBRA benefit.
Yeah.
Correct?
So, and I'm going to just chime in real quick. We talked about this a little earlier as well. Unless gross misconduct's always really hard in the COBRA context, because they wouldn't be eligible for COBRA if they're terminated due to loss coverage due to gross misconduct. The problem is you bring in all the employment type of issues to prove the gross misconduct. And if you're wrong and they find out it wasn't gross misconduct, then you've had this issue of you haven't offered COBRA for X period of time, and then all of a sudden you're subject to all these penalties, right? So I've always taken the approach, and again, this is just me personally, that unless someone comes in and robs the CEO in the office, it's really hard to prove gross misconduct. And a lot of times it's just not worth the chance that you're going to take unless it's just, like I said, painfully obvious.
But to the point there, I've seen this question flashing across, and it was also in a pre-prepared question that was circulated. Gross misconduct still cuts off COBRA. So if you have somebody that is terminated because of gross misconduct, they don't have a COBRA right. Yep. And that's an example of how the subsidy layers on top of the general overall structure there. You can terminate someone for cause, and they're still subject to the subsidy if it's not gross misconduct. And that was a point that was made under notice 2009-27. We've got an into that. Reduction.
I can ask you a question as you're looking
Sure.
something up. I've seen a couple questions come up today, and I know one question that came in advance asked about how dependents are affected by the new COBRA rules. Are they able to get on COBRA if the former employee elects still?
Yes, dependents, if you've got family coverage, first of all, you've got to go back into the normal COBRA construct. If I've got or you've got family coverage, and I'm the employer, or I'm the employee, or you are, and I lose coverage, or I am terminated from employment in a way that satisfies the requirement under the ARPA, and my dependents and spouse are covered immediately before and lose coverage because of the termination, involuntary termination, those people too are going to have the right to the subsidy. So that coverage will be fully subsidized for all of those people that are traveling in the family coverage. By the same token, if I only do employee and spouse, or I do employee and dependents but not spouse because my spouse is working somewhere else and has separate coverage, I'm terminated, I lose coverage, and then I can elect and my dependents can elect, but my spouse cannot, because she was not covered immediately prior to the event and didn't lose coverage because of it. And so even if she were to, she's just not eligible for COBRA, so the subsidy wouldn't apply, period, anyway. But even if there were, even if something were gratuitously offered to her, you wouldn't be able to get the subsidy from that. So that's where we're getting into some of the nuances that will come out in the notice, because some of those questions were answered in the old 2009-27. You have another good question?
Oh, I have plenty of good questions. There are no bad questions here. They're all good questions.
Yeah.
So another question that came up before the chat, this was submitted in advance. And folks, as we do these in the future, I'm going to take a week off next week from doing these Zooms because I have to pick up my kids at school on Friday. They've early dismissed. But after that, submit your questions in advance. It's a good way to get them answered. A question that was submitted in advance. Is the 100% employer paid COBRA only for medical health insurance, or could that also extend to vision and dental?
Bob, you want to field this one?
Well, I'd say it extends to dental and vision as well.
Okay, that was an easy one.
Yeah, it really was. I mean, it does exclude if they're like standalone voluntary, but typically dental and vision is going to be within your health plan guidelines for the premium.
Even if it's carved out and treated as a separate type of benefit pursuant to which there would be an election, it is the provision of medical services under the Internal Revenue Code. So that's
it's deemed a health plan for purposes of this.
I see a good question right now from Nixalese, and there was also a question submitted in advance that's pretty similar to it. So I'll ask them both, and then you guys can answer whichever one you want first. And the question in the chat is, if a current employee is out of work due to my screen just scrolled, due to a temporary disability or surgery, is that person eligible for COBRA, or does the employer just continue paying benefits as usual? So maybe we can just pause there. It looks like, Bob, you're getting ready to answer that one.
I was going to let Mark answer that.
Oh, okay.
Oh, okay.
That's always one of those weird issues of it just depends on a lot of variables. So go ahead.
Okay.
Yeah, I mean, they're going to, if they're going to continue the coverage as the employer during the normal course, during a leave of absence and whatnot, then they're not going to be eligible for the subsidy. If the employer takes steps to terminate them involuntarily, then that would trigger the ability for them to make the election to get the to get the COBRA and at least get the subsidy from April 1st to September 30th.
What about someone who has their hours voluntarily? What if someone voluntarily reduces their hours?
Yeah, that one's pretty thick. And if you voluntarily, if you have, the first response is generally no. That's the general rule. No, if you voluntarily terminate or voluntarily reduce your hours to the point where you lose coverage, because remember, you have to have the event plus the loss of coverage under COBRA, then that's not going to generally trigger the subsidy. There are facts where in the notice in 2009, pretty nuanced, where they did allow a reduction of hours on an involuntary basis, but it had to be for 0 hours. So in other words, even if they go on to a reduced schedule and lose group medical coverage because of it, and that triggers a COBRA right, then they're not going to be eligible for the subsidy because they haven't been terminated at that point.
Okay. A question that popped up earlier. Public employers, are they covered under this COBRA subsidy, or is it just
yes?
Okay.
Yeah, they're covered under the Public Health Service Act.
Okay.
Yeah, and that has a parallel provision to it. COBRA's repeated in multiple places in the United States Code, and the Public Health Service Act is one of them. The Internal Revenue Code's another one, and it's also in ERISA. So, it wasn't enough just to have one. We had to go out and make the problem. Let's just multiply it.
That's what you do when you get 600 plus pages of legislation that gets signed into law in a matter of less than a week. Some things fall through the cracks. How about, Jennifer May asks, how about an EAP, an employee assistance program? Is there, if someone leaves, if someone, let's say has a substance abuse problem or something like that, and they need to take time away from work and involve an EAP, can that be considered a COBRA trigger?
Well, it really depends on if the EAP itself is subject to COBRA, and that's going to be based on if it actually provides for medical services. And where that gets kind of ticky is where if you provide for a referral to services, then it's not providing medical services. If your EAP actually says that you get 6 visits with a therapist or whatever the case may be, then you're providing medical services, and then you'd be subject to COBRA. The problem you're going to run into with the EAP, and again, this is kind of high level, generally speaking, most places can't determine the cost for the EAP because a lot of the insurance companies just kind of toss it in and charge maybe $1 a person and whatever the case may be. So, not knowing their particular situation, I would say it was subject to COBRA if it provides medical services, but the subsidy, I don't know if it's really an issue or not.
Okay.
Yeah, but keep in mind too there that, if we've got somebody, it's kind of like the person who was out because of surgery. If they're going out on a short, if they're going out on a leave program, even if they're not getting group medical coverage while they're on their leave, they still have to have an involuntary termination of employment. And so we've got to keep going back to that time and again, because, skipping that step will get us into trouble.
Right.
And that's where we're waiting on the Internal Revenue Service to fill in some gaps, right? Because I see some questions coming up. The recurring question that I see in the chat window is, what happens if someone goes out on disability leave? They're out for a while, 6 months, LTD kicks in, and it's clear they're not coming back.
Yeah.
So the employer effectively accepts their resignation that they're not going to be able to return. Does that count as an involuntary separation of employment, or is it voluntary because the employee said, look, keep them back?
Disability, being out like that, typically is a protracted kind of process, and it's peculiar to the companies. And the key point is, at what point is a person terminated? And if you are out on a short-term leave, and then you go through paid time off, you go through your sick leave, then you go through your short-term disability, which is usually just a payroll practice within the company. By the time you're transitioning into long-term disability and you go past the eligibility wait period, that's usually a point at which someone is terminated from employment. And so, there it is. That's kind of the line of demarcation whenever companies really kind of cut that cord. If somebody's horribly disabled, their cognitive function is out. I think that is, that's definitely an involuntary termination. But we'll have to wait and see. In addition, I'm just reading from the notice here. In addition, involuntary termination does not include the death of an employee, or that's for COBRA purposes.
As a practical matter, and I'll throw this out to either one of you, in that situation where we have someone who really can no longer come back to work, is the employer in any way harmed, prejudiced by setting up the separation of employment as an involuntary? So have it be the employer who says, we're going to terminate you without cause because you can't come back to work. And you're almost doing the employee a solid, because then they can get that 6-month COBRA subsidy.
I would not be afraid of that, to tell you the truth, because you've got, it's a facts and circumstances analysis. from the perspective of whether or not it's an involuntary termination of employment for purposes of the subsidy. And so if we've got somebody that is terminating, say for example, if you quit in lieu of being terminated, so I know that I'm about to be terminated. They told me I'm about to be terminated. I want to avoid the stigma of having to say I was terminated from employment, so I'm going to quit instead. That's an involuntary termination under the old rules. I fully expect that that's going to be carried over into the new rules here once they're issued. Here's another one.
Go ahead, Bob.
This isn't really dealing with the COBRA, but just something to pay attention to when you start dealing with people out on disability and you start stretching over these different time periods like Mark was talking about. A lot of carriers in the last couple of years have changed the language in their plan documentation and the contracts, where it used to say any employer approved leave of absence and really didn't give a time frame. Seen a lot of them where they limit it to 30 or 60 days. So that way, before they have to be kicked off the plan and not considered an active employee. So just be aware of those things. Again, not in the COBRA context, but if not, you're self-insuring everybody. If you got somebody on, that you've been carrying for 9 months because they're on some sort of disability plan, make sure your document's allowing for that.
Here's a cut to the chase question, because I know employers are going to ask this. How and when do employees get the subsidy?
That's an easy question. You just don't have to pay your COBRA premium. You just, and in fact, if you do provide part of a payment, you're supposed to get that money back. You're supposed to get a credit for it. And so you just simply do not pay the COBRA premium. In 2009, you had to pay 35% of the premium. There was an income phase out, but that is not in this law. And so it's 102%. So whatever the freight is that you charge for COBRA for an individual, individual plus one, or a family, and any of the variations there. So if there's a separate premium that attaches for dental or vision, then they're just not going to pay those anymore. And the way the employer gets its money out of there and gets reimbursed for that is it offsets employment taxes. And so just like in 2009, you're going to see I think it's a 941X that the service will be issuing with instructions where the employer is going to need to track all of this, and then the payroll function is going to have to be included in that. And then they're going to have to understand the number of people that are entitled to the subsidy and how much the subsidy is, because they're going to have to offset that from the employment taxes that they would otherwise remit to the federal government. And employment taxes are, that's a very arcane and tricky practice in and of itself. So there are provisions in the law for this. For example, you can't be charged late for late deposits. The employer can get an advance on it. And so from an administrative perspective, the folks that are in the HR function and group medical are going to need to be able to pull and get information over to the payroll department, so those payroll people can get that subsidy back, because that subsidy is coming ultimately out of the employer's pocket. And so the employer is going to want that back. But for the employee, or for the COBRA, the former employee, excuse me, because they had to be terminated, you are going to have to, they're just not going to pay for their coverage. Now, once, and here's another nuance that comes in there too. It applies to we think it's going to apply to the first period beginning on or after April 1st of 2021. So if your COBRA normally operates on a monthly basis and you pay a monthly premium, it's going to be that first premium that the employee would otherwise need to pay after April 1st of 2021. That's going to be excused, and the last payment that's paid before or on or before September 30th of 2021 is also going to be excused. And so after that, then the employee is going to have to switch back on and start paying their COBRA premiums. So think about it, if you're an HR person, if you're in management, on employee plans, you know, some of that stuff is going to have to be turned back on. And so there's, you know, a beginning and an end to this thing.
Just to be clear, closing the loop, if someone has access to other health coverage, maybe on a spouse's plan, or they can get health coverage through the marketplace, they are no longer eligible for the subsidy. Is that correct?
Well, it's not, you know, yeah, correct. If you get eligibility for another group medical plan or eligibility for Medicare, then the law literally reads that, you know, that's when it cuts off. And there's an obligation on the employee to notify the employer so that the employer can shut off the subsidy. And in fact, there's a penalty if it's unintentional. The penalty for failure to provide notice is $250. If it's willful, premeditated, I guess you would say, then it goes up to 110% of the subsidy that was paid, but for the fact that they would have been cut off. It's not clear from the law how this is going to interact with the exchanges. That's the one thing that's not out there.
I was going to say they don't say anything about being eligible for the marketplace. It's Medicare and employer sponsored coverage. Just to make sure that, you know, we don't exclude marketplace people as of right now.
Okay, thank you. How about, there was a question that came in advance about someone wrote, as a nonprofit organization which has been designated by the IRS to hold 501c3 tax exempt status, how do we set off the COBRA? How do we offset, excuse me, the COBRA expense? Does that question make sense to you?
Yeah, so it's payroll taxes. So 501c3 is going to be paying those as well. Okay. So it really has, you know, I don't want to say it has nothing to do with their tax exempt status, but it's all through employment status, and that's the reason they do it that way.
Yeah. So in other words, if you're an employee of a 501c3 and they're paying you, they're withholding your federal withholding, and you applied to employment taxes, and that's where it's gonna get caught at that point. And so the nonprofit will be reimbursed for the out-of-pocket that it incurs if it's the sponsor of the group medical plan.
Let me ask you another practical question. Sometimes when you're terminating employees, you set up, you have a severance agreement set up with your employee that, as part of the consideration for releasing your claims against the company, we're going to give you a severance, and we're not going to contest unemployment, and we're going to give you a positive or a neutral reference, and we're going to continue to pay for your health benefits under your current plan for a couple of extra months. Is there any real incentive for an employer to do that now, considering that you just could otherwise say, hey, go on to COBRA and it's going to be free for 6 months? Wouldn't you just do that at this point?
You can certainly do that.
Yeah.
Somebody just asked about the employment tax. It's the 1.9%. It's the hospitalization portion of FICA. And so the employer's rate on that, I think, is 1.45. But I'd have to double check that. And I think they can also claim the amount that the employee would have otherwise paid on that too.
Also, someone just asked, and I want to make sure we're crystal clear. Someone asked, so marketplace people will be offered the subsidy? And it seems like the answer is yes, they'll be offered the subsidy, because it's unclear right now as to whether that's a disqualifier, but maybe the IRS might weigh in at some point and change that around.
Well, so they will receive the notice if they're one of the people that are eligible, you know, if they're one of those that elected not to have COBRA and went to the marketplace. Mm-hmm. Right? It's not a subsidy for the marketplace payment. It's only a subsidy for COBRA. So they'll get the notification And if they elect to go back to COBRA, as of right now, the way it reads, that they would be allowed to go back to COBRA and get the subsidy.
Why wouldn't you elect the COBRA and go directly to the marketplace?
You talking about like a time of COBRA, like when before all of this?
Right. Let's
so
just someone's eligible for the COBRA subsidy starting on April.
Yeah. So,
why would you throw that aside and go to the marketplace?
I don't think you would. I'm saying it's like if you go back 18 months and someone was on, instead of doing COBRA at the time, they went to the marketplace. The marketplace does not exclude them from getting the notice.
Got it.
And as of right now, it doesn't. You know, if they went to the marketplace, if say for example they decided they didn't want to have the COBRA anymore, so they quit paying the premiums, and so they went to the marketplace to the exchanges and bought coverage there. It's the law does not preclude them from being eligible assistant participants.
Right.
And so and likewise, you know, if they're on COBRA and they decide to go onto the exchanges, there's nothing in the law that says this right now that cuts off coverage. But if they become eligible for employer coverage or Medicare, then that precludes them from being eligible for the subsidy. So we'll have to wait for the service to finally weigh in on that one.
Well, let's do a little bit of a reset. So people who are joining in right now, I'm Eric, that's Mark, that's Bob. We're answering COBRA questions right now in connection with the American Rescue Plan Act. I think we've been doing a pretty good job of giving non-legal advice that isn't creating any sort of attorney-client privilege, because that's not what we're doing here. If you do have specific questions, maybe ask your outside employee benefits counsel, but we'll do our best to answer your hypothetical questions in the 15 or so minutes that we have left. Here's a good one that just came in from Kristen. So we were talking a few minutes ago about severance agreements. What happens if you already entered into a severance agreement earlier in the year and the company has been paying for COBRA as part of the severance? So, you know, employee elects to go into COBRA, and as part of the deal, the employer is paying for it. How does that change at all come April 1?
I'm not clear on that, and I didn't see anything in notice that dated back to 2009 that addressed that issue. I would expect that the service would ask that, or would answer that question.
Yeah, that seems like FAQ number 38. They're going to get around to that at some point, for sure.
Yeah.
Yeah.
It's, you know, I haven't seen anything. My default would be that the employer can go ahead and claim claim the subsidy, which would be kind of a windfall, because it's, you know, it's not, it would at least pay for their coverage. As opposed to being fully subsidized.
Yeah, and we'll see what they say, because they're, you know, obviously the company's paying for it. They're not a qualified individual for this thing, so that would be their argument. But anyway, that actually leads into two things, and I think someone actually asked the question regarding at the end of the subsidy period, is there anything about what's the qualifying event? Can they get onto the marketplace? Would they be eligible for the marketplace at the end of the subsidy? And we haven't seen any guidance on that as of right now. I think there's going to be, I anticipate a lot of things coming into play with the marketplace, because they're not going to want people running off the marketplace to get back on COBRA, because that will mess with their numbers as well. So I think there's probably going to be, you know, to Mark's point, 10 to 15 pages of just how the marketplace is going to interact with the COBRA subsidy is what I would anticipate. So
someone just asked, it's more of a statement. So she's looking for confirmation. Sheree just asked, just to make sure I understand, if an employee is terminated, not on our payroll to recoup via taxes, the employee pays premiums directly to the COBRA plan, then the subsidy is simply direct to the employee of 102%. by not having to pay the premium, and nothing additional would need to be done by the employer in this situation? Do you guys follow that? It's a long one.
Yeah, that's a long one. You got several things going on there, I think. So we've got somebody who was involuntarily terminated. They're on COBRA. They are on COBRA for a period of time between April 1st of 2021 and ending September 30th of 2021. And then that will become subsidized during that period of time for periods of coverage for the premiums there. And so the employer will not need to do anything for that person there. They'll need to provide, that assume that they were already on COBRA. You could have another construct where they didn't elect COBRA, but you have to provide them with a new notice. But they would not pay for their 102% of their COBRA, but the employer is going to need to act through its payroll function to get reimbursed for the 102%. And keep in mind too, that goes just beyond the employee. It goes to all of the qualified beneficiaries or qualified people under COBRA. So if that person's on employee plus child or family or employee plus spouse, then we've got the issue of whatever the COBRA premium is there. And there were specific rules in 2009 on the pricing and how the subsidy works if the pricing is in bulk and everything. So we're going to need to account for that. You'll have to watch out for that. Either call us or talk to the group medical people who are going to be administering COBRA for you.
Jennifer has a question. I suspect I might even know the answer to this one. How will the government know when someone had coverage elsewhere but jumps onto COBRA to get the subsidy? I'm guessing that's going to be part of the model notice, right? That you got to complete.
Yeah, I think I hadn't even thought about that. They may be able to pick that up through you get a I can't remember what the number of
the 1095. They'll pick it up through ACA reporting that's required through the companies. And you're also basically, I anticipate signing an affidavit saying that you don't have coverage anywhere else. Surprisingly enough, the government has been able to match all of these things up with the different reporting that's required from companies now with regard to, the employer has to certify that they're offering health care.
Mm-hmm.
So that's how they'll deal with the employer side. And then Medicare, they'll have the kind of the same thing. They'll have records of that. I'm not saying they'll catch everybody, but they are pretty good at wrapping all that up.
And here's an important caveat to that too. The employer, there's going to be probably a hold harmless provision. So if an employee doesn't provide notice when they were in fact required to provide notice, and then the employer got the subsidy, it's going to be a no harm, no foul situation with respect to the employer. Now, I'm assuming that, there's not going to be an abusive situation there, in which case it would probably go after an employer who's taking subsidies when they shouldn't.
Fellas, I got to tell you, you got a fan club building here. If yours wasn't big enough already, we've got a request already. Can you do another webinar with Mark and Bob when the IRS and DOL supply the 15 to 20 pages of guidance and rules? Here's the condition on that. If Mark and Bob are nice enough to do it, we're gonna have to start a GoFundMe because that's gonna be the booze and benefits. All right. So we're gonna need enough money in the GoFundMe to make sure they have some nice, whatever they drink, Johnny Walker Blue, a blended, whatever your drink is, we're gonna have to make sure that they are nicely lubed up to sift through 15 to 20 pages. But if you want Mark and Bob to come back at some point when the IRS and the DOL supply the guidance, just let us know in the chat. We'll certainly take that into account. Appreciate it.
I'm more than happy to do that. I can't volunteer my compatriot over there, but we'll be looking at these, and feel free to call us as well.
Yeah, let me before I forget, I've been doing it throughout. Let me again put all of their contact information in the chat window. There's a link down here. You should connect with Mark and Bob on LinkedIn for sure. Here's a link to our firm's website. All of our bios are there. And obviously, you can check out the YouTube page as well. We have about 10 minutes left. Is there anything, I'm looking at our agenda right now. I think we did pretty well at hitting our agenda points. Is there anything else you guys wanted to touch upon before I turn and look to see if there are any additional questions? We're not doing this for CLE credit, so we don't have to go the full hour if we don't want to. All right. Let's see. Here's a question. I know we're waiting on further guidance, but who would, and I apologize if we answered this already. Ginger asks, I know we're waiting for further guidance, but who would qualify for a reduction in hours? Is there a magic formula for that?
So I'll let Mark go into the, was it Q&A 3 that you were getting from? It's not just a reduction in hours. It's really a reduction in hours to zero.
Zero.
And this is coming from, if any of you, in the last year went through the analysis of you were going to do a furlough or you're putting somebody on leave, but you knew you were bringing them back in 3 months or 6 months. There were a lot of discussions back then of, do we terminate the person? Do we treat them as something else? Do we just treat them on leave? And there was a lot of interaction between employers and council and the providers, because like I said, the providers kind of changed all the language to say how long someone could not be actively employed and still be eligible for the plan. So what they did is they said the reduction in hours, I'll let Mark get into the details, but I think he has it right there, not to put you on the spot, but I know that you were reading.
I'm looking at it.
Yeah. So that's kind of it's not just a reduction in hours, like somebody going from 40 to 20. It's actually somebody that's going to be on leave. Mm-hmm. And I'll go ahead and let Mark turn that over to Mark right now.
I'm just going to read this to you. It's kind of, you'll have to listen closely. This is Q&A 2. Does an involuntary termination include a layoff period with a right to recall or a temporary furlough period? Yes, an involuntary reduction to 0 hours, such as a layoff, furlough, or other suspension of employment resulting in a loss of health coverage is an involuntary termination for purposes of the premium reduction. Q&A 3, does an involuntary termination include a reduction in hours? Generally, no. If the reduction in hours is not a reduction to 0, in other words, you have to hit 0, the mere reduction in hours is not an involuntary termination. And this is an important caveat here. However, an employee's voluntary termination in response to an employer imposed reduction in hours may be an involuntary termination if the reduction in hours is a material negative change in the employment relationship for the employee. And so that's where you loop in, basically, where you have an instance where you have a voluntary quit. And that kind of goes back, and that's its cousin is the good reason. So you have some type of change that's material enough to the employee, in connection with the reduction of hours. I had changed circumstances, so I just did an involuntary termination at that point. And then I'm entitled to the subsidy. Now that's going to be difficult to administer. You're going to have to, that's going to have some record keeping that's associated with it, because those are pretty nuanced situations.
A couple questions are coming in the we're getting into the 9th inning here, folks. Couple questions came in. Not sure if you answered this already. What if an employee was terminated in January and did not elect COBRA at the time? If the terminated employee now elects COBRA, would they have to go back to December and pay full premiums through March in order to access the subsidized COBRA premiums starting in April?
No, it's a new election. And so, the way to think of it is once they elect, because we have a new election right that's required by the employer. Once they elect, it will go and jump in place based upon that election. And then, go back to April 1st is what it's going to go back to. Then the subsidy is going to apply, but they're only going to go to the end of what the original 18-month period would have been. So there you've got to record keep this and go all the way back from when that person had an involuntary termination from employment and then lost the coverage, because if that ends sometime in between those two dates, that's going to be the end of the subsidy. And so that's going to need to be tracked, within the administrative systems, so that you know that the employee doesn't owe a premium, and that your payroll department's claiming the subsidy, so it's reimbursed for the fully subsidized COBRA coverage.
Yep.
Let's go to the other end. Let's fast forward to September 30th. Someone stops, they're on COBRA, they stop getting the subsidy. Presumably they start paying premiums. Do they just start paying premiums at that point, or does that open a subsequent special enrollment period? How's that mechanically going to work?
Well, you've got to provide a notice. There's going to be another model notice that's on the back end. So DOL is going to give us a model notice that we have to provide within a certain, or that the employer has to provide within a certain period of time before the subsidy ends. And so it will give information about that. Now, if you went back and looked at the law in 2009 and the way the Internal Revenue Service dealt with it at that point in time, what they did is for that last, premium cycle, the payment for which falls on or before September 30th or September 31st, whatever the date is, then that will continue that coverage. And then once you have the next cycle, then the employee is going to have to turn that back on. So the employer is going to have to know and be able to monitor, we're supposed to get the subsidy. And then that's going to be, we're supposed to get the 102% from the employee. And then you're going to have to start, your periods with respect to monitoring, and your grace period with your regular COBRA feature at that point. I suspect there are going to be a lot of people that are going to be signing on for the subsidized period, and as soon as it turns off, they're just going to let it lapse.
And
go ahead, Bob.
I would say, and that's why I am anticipating them to do something with the marketplace to create a special enrollment right for the marketplace, so people can jump back and forth or figure something out there. Because what's going to happen is you go from paying zero to all of a sudden you're paying $1,900 a month. Most people aren't going to be able to afford that monthly thing, and they're not going to be eligible right now to go to the marketplace and get anything. So I would anticipate that coming out in the next, that may not be in the initial guidance, but within the next 2 months to kind of clarify that for us.
All right. We'll get about 3 minutes left.
So there's a couple of questions about the going from 40 hours to 20 hours, going full-time to part-time. That is a COBRA qualifying event. As of right now, the way that it reads is it's not an involuntary termination, though, because it has to be a reduction of hours to 0. So while it is a COBRA event, it's not a subsidy event.
Yeah, and one way to illustrate that point, and we don't know how the Internal Revenue Service is going to interpret this. This part of the relief legislation is very similar to the 2009 law. And so what they said there is, if you have a divorce, if a child ages out of the coverage, if there is eligibility for Medicare, all of these other different things that would trigger a COBRA right, that's not going to apply. So say, for example, if you're married and you get a divorce, and that triggers a COBRA obligation on your spouse, and then you're later involuntarily terminated from employment, and you have yourself plus your children as covered, the spouse is not going to have the special enrollment right, because it wasn't lost in connection with this involuntary termination. It was lost in connection with the divorce. And so there are going to be those types of nuances that go out there. So she would not have the election right, the new election right under the reform, plus she would not be eligible for the subsidy. And so, they could take another direction on that, but that would really broaden the law out and say, okay, any COBRA qualifying event that's not a voluntary quit applies and for the subsidy. And I can't imagine that they're going to take that position, but they could.
All right. Well, folks, we got a minute left. I'm going to shut it down here. Weren't they great, guys? Mark Mathis, Bob Ellerbrock, thank you so much for coming out and sharing your wisdom on a new law that is still in flux. We are, hopefully I can convince them to come back when we get some regulations. But otherwise, if you have questions, if you want to get in touch with them, I posted the information. You guys want to share your email addresses? We got mark.mathis@FisherBroyles.com. Are you Robert.Ellerbrock or Bob.Ellerbrock?
Robert.
Robert.Ellerbrock@FisherBroyles.com. I will spell Fisher. Whoops. Let's see if I can do this right in the chat. There we go. FisherBroyles.com. Thank you, everyone, for tuning in today. I had a great time. I learned a thing or two. And again, we're going to post this to YouTube. It'll be up there on the channel. I'll have links in the blog come Monday. And going forward, folks, if you have other topics that you'd like to hear about at these Employer Handbook Zoom sessions, let me know. Email me, message me. I'd love to hear from you. Otherwise, everyone, thank you for showing out. Stay safe and have a wonderful weekend.
Thank you all.